everyone, I'm Anshika Agarwal, working as an intern in LEXIS and Company. So today I will discuss about First Information Report. It is commonly known as FIR. Usually we listen that X person filed an FIR against Y person, or we generally say that I will file a FIR against you sarcastically to our friends. So, do you guys really know the concept of FIR? So let's discuss about First Information Report. First Information Report, that is FIR, is a written document prepared by the police when they receive information about the commission of a cognizable crime, cognizable offense. So, what is cognizable offense? It is an offense in which the police may arrest a person without warrant. They are authorized to start an investigation into a cognizable offense in a cognizable case on their own, and they do not require any orders from the court to do the same. A police officer is bound to register a FIR in such cases and can even start an investigation without any FIR. These are heinous crimes generally and non-bailable offences. First information report is a report of information that reaches a police first in point of time, and that is why it is called First Information Report. It is generally a complaint lodged with the police by the victim of a cognizable offense or by someone on his or her behalf. Anyone can report the commission of a cognizable offense either orally or in writing to the police. Even a telephonic message can be treated as an FIR. If the information given by the woman against whom an offense is committed under section 326A, 326B, 354, 354A, 354B, 354C, 354D, 376, 376A, 2E and section 509 of Indian Penal Code, is alleged that such information shall be recorded by a woman police officer. One should sign the report only after verifying that the information recorded by the police is as per the details given by the person, that is the complainant. People who cannot read or write must put their left thumb impression on the document after being satisfied that it is a correct record. One should always ask for a copy of FIR if the police do not give it to you. And do you know, it is a right to get it free of cost. Though FIR is not defined specifically anywhere in the code, but it means information relating to the commission of a cognizable offense given to the police first in point of time, which is provided under section 154 of the Code of Criminal Procedure 1973. So do you guys know what a non-cognizable offense is? If yes, do mention in the comment section. So, do you think it is mandatory for the police to investigate every case reported to them, as on a daily basis thousands of cases are reported? So, to answer this, the police may not investigate a complaint even if you file an FIR when, number one, the case is not serious in nature. Secondly, the police feel that there is not enough ground to investigate. However, the police must record the reasons for not conducting an investigation, and in the latter case must also inform the complainant, which is given under section 157 of the Criminal Procedure Code. So where the FIR should be filed? An FIR should be filed in the police station of the concerned area in whose jurisdiction the offence took place. So following is the procedure of filing an FIR. Section 154 of the CRPC lays down procedure for filing an FIR. Number 1 is in written form. When the information about the commission of cognizable offense is given orally, then police must write it down. Second is read over. A person giving the information or making the complaint can demand that the information recorded by the police to be read over to him or her. Third one is verification. One should sign the report only after verifying the information recorded by the police is as per the details given by the person. Last is signature. Once the information has been recorded by the police, it must be signed giving the information. It is to be kept in mind that people who are unable to read or write are expected to put their left thumb impression on the document after being satisfied that it is correctly recorded. If an informer refuses to sign the FIR, he is guilty of offence under section 180 of the Indian Penal Code and shall be punishable with simple imprisonment for a term which may extend to 3 months, or with fine which may extend to 500 rupees or with both. If the police officer refuses to enter the FIR and state enters in DD register a totally different and false report, he is guilty under section 176, 167 and 218 of Indian Penal Code. A person filing an FIR has the right of getting a copy of FIR from the police station free of cost. So, can a multiple FIRs be filed for the same cause of action? For this, in the case of Surendra Kaushik and others with the state of UP, it is quite luminous that the lodgement of two FIRs is not permissible in respect of one and the same incident. The concept of sameness has been given a restricted meaning. It does not encompass filing of a counter FIR relating to the same or connected cognizable offence. What is prohibited is any other further complaint by the same complainant and others against the same accused subsequent to the registration of the case under the code. For investigation in that regard would have already commenced to an improvement of the facts mentioned in the original complaint. As is further made clear by the three-judge bench in Upkar Singh case, the prohibition does not cover the allegations made by the accused in the first FIR alleging a different version of the same incident. Thus, rival version in respect of the same incident to take different shapes and in that event, lodgement of two FIRs is permissible. Supreme Court also issued various directions to be followed in regards to the registration of an FIR in the case of Lalita Kumari versus Government of Uttar Pradesh. So, do you know why is FIR so important? An FIR is very important document as it sets the process of criminal justice in motion. It is only after the FIR registered in the police station that the police takes up investigation of the case. So, who can file an FIR? Anyone who knows about the commission of a cognizable offence can file an FIR. It is not necessary that only the victim of the crime should file an FIR. A police officer who comes to know about a cognizable offence can file an FIR himself or herself. In fact, you guys can also file an FIR if you are the person against whom the offence has been committed. Secondly, you know yourself about an offence which has been committed. Thirdly, you have seen the offence being committed. So any person who is aware of the offence by being either an eyewitness or hearsay account by the accused himself or by the SHO on his own knowledge or information, even when a cognizable offence is committed in view of an officer in charge, he can register a case himself. However, he is not bound to take down in writing any information, and even if the information is only by a medical certificate upon arrival of the injured, then the SHO should enter it in daily diary and go to the hospital for recording the detailed statement of injured. So what happened when police officer refuses to register an FIR which is against the law? Although if an FIR is refused on the ground of jurisdiction, it is mandatory for the police officer to record information about the commission of a cognizable offence and forward the same to the police station having proper jurisdiction. Otherwise, it would amount to dereliction of duty. Here comes the concept of zero FIR, a type of FIR that can be filed in a police station regardless of the place of incident or jurisdiction. However, after investigation and filing it with the magistrate, it transferred to the police station which is competent jurisdiction. It is to be noted that a normal FIR has a proper serial number. On the contrary, the zero FIR is registered in any police station and hence is not numbered. That is why it is known as zero FIR. So what is the consequence of filing a false FIR? For filing a false complaint or giving wrong information to the police, you can be prosecuted under the law for giving wrong information and for misleading the police under section 203 of Indian Penal Code. So what is FIR? EFIR is a short form of electronic FIR and it can be filed in cases of cognizable offences like rape, murder, dowry death, etc. Its main agenda is to protect the identity of such victims who may not be able to file FIR at the nearby police station for reasons such as social pressure, inability to face the society, etc. Though there is much more to tell about the FIR, but that's all for today. Bye bye, stay safe.